Thank you very much, Matthew. I'd like to welcome our second speaker today, who is Professor Charles Lawson from Griffith Law School, Griffith University, who will be talking about compulsory licensing of patents.
Thank you for inviting me along. I want to talk about compulsory licensing. I guess in the context of the UN report, what makes it interesting is that compulsory licensing is seen as a solution to part of the patents problem. I guess I would challenge whether that is the case. And that's mostly because compulsory licenses gets tied up in complex processes and procedures. So in most instances, it's not really a solution. I'm going to talk quite quickly because I've got quite a lot to say and I want to get through it. I guess we'll take questions right at the end. Okay, so starting up. This is what I want to talk about. I want to talk about compulsory licensing theory because I think when you understand the theory of what compulsory licensing is about, you can see the difficult problem that faces regulators and policymakers about how to draw the balance between more patents or more compulsory licensings. There is no right answer here. It's a complex one. Then I want to talk about those TRIPS obligations. What are the minimum standards that are required for most countries. Then I want to talk about the licensing landscape, the places and numbers. And really what I want to highlight here is that the incredibly effective role of the social sector in forcing patent holders to license and make their drugs accessible. It's been incredibly successful. I guess then I want to talk about perhaps some of the reasons about why there are so few compulsory licenses. And then I want to give Australia as a good example of a state which complies with TRIPS, but then show you how it's all tied up. So it really is not a practical solution. And then I guess some conclusions. So looking at the compulsory licensing theory, just to go through so we're clear what we're talking about. A patent is a grant of exclusivity for a term of 20 to 25 years. And essentially you get exclusive rights. And those exclusive rights cover products and processes. And that's essentially the marketing, the using, offering for sales, selling and importing the products and also the products of the processes. And these are the obligations, the minimum standards required by TRIPS. Then you have compulsory licensing, and essentially what that does, that enables essentially a competent authority, the governments, to license a third party to use that patent. Without the consent of the patent holder, there needs to be some kind of adequate remuneration. So essentially the license is allowing a third party who's unrelated to use that patent protected process and the products of that process. Now looking at the theory, and this really is this pact. It's a complex one. Essentially, the idea is that if you reduce or restrict competition, and you do that with the grant of a patent, what that does is that results in an increase in prices and reduces the access, and that leads to less and more expensive drugs and less in the quantity of drugs. Secondly, the second scenario is if you increase or de-restrict competition. So in other words, you grant more compulsory licenses. What that does is that lowers the price and then it increases the access. So that leads to the quantity of drugs available will increase, but you'll also have less expensive drugs. So that sounds good. That sounds like that's essentially what drives our modern economies, this idea of more competition, lowers prices, increases access. But there's another important consequence of this, and I guess this is the complexity when we talk about patents, is that when you have less compulsory licensing, so you have stronger patents, then you get more invention. And the idea here is by giving that exclusivity to the patent, you end up with more innovation, more invention, things you otherwise wouldn't have had but for the patent. And the consequence then is if you have more compulsory licensing, so you have weaker patents, what you end up there is with less innovation. So we have this conundrum. Without patents, we don't have the new drugs to combat diseases, but so we need the patents to get us the new drugs and the new inventions to treat those diseases. But the other side of it is that without compulsory licensing, we don't necessarily have access and the prices are high. So we need compulsory licensing to give us access to those drugs and also to reduce the prices. So let's look at how that works in practice. And this is looking at the TRIPS obligations. And really what I'm going to talk about is compulsory licenses. But compulsory license is really just part of the scheme that is set out by TRIPS. So our basic TRIPS obligations for compulsory licensing are set out in Article 31. And that really is talking about what's called other use without authorisation, and we use compulsory licensing as a shorthand for that. But there are essentially two schemes. There's the classic, what we call compulsory licensing, and that's the failure to work, the refusal to deal, the anti-competitive practices, public interest, a whole range of those kinds of criteria. And essentially the difference between compulsory licensing and government use, and the government use is the other form, is where the government then uses the invention by itself. So if the government is using it, there's a government use provisions apply. If it's someone other than the government, so essentially a third party, then you have the compulsory licenses. We have the Doha Declaration, which was a significant advance on how TRIPS might be implemented. And most importantly, what it did is it gave an indication of the members, so it's quite a high-level declaration of the members about how TRIPS could be applied. And essentially there were three aspects to the other use without authorisation which are addressed by the declaration. The most important one for our purposes is paragraph 5b, and there the declaration confirmed the freedom to determine the grounds on which a licences are granted, but also it dealt in paragraph 6 with a regional waiver, and that this is pending in TRIPS' an amendment to TRIPS in Article 31 bis, and we have legislation in Australia now which allows this kind of para 6 process. Essentially what it does is allows manufacture of drugs in countries where their patent applies, and allows them to export those drugs to developing countries or countries that don't have the manufacturing capacity. And I'm sure some others will talk about that. And then we have finally the paragraph 7, which is significant for poor countries because it's the least developed country waiver. And essentially what that allows is that doesn't require the least developed countries or the LDCs to implement patent standards, so it allows them to essentially exploit the patent in their territory. The problem there is that they don't have the manufacturing capacity to take advantage of that. And that's why we have the para 6 of the Doha Declaration arrangements. Now I'm only looking at the TRIPS Article 31 compulsory licenses in what I'm talking about now. So essentially what TRIPS Article 31 requires, and essentially remember this is the other use without authorisation, and there are a series of criteria you have to satisfy and limitations on the kinds of circumstances when you can have what we're calling compulsory licence. And the conditions and procedures mandate this general authorisation. So each case is considered on its own merits. You need to have reasonable efforts to obtain a voluntary licence, and that should have failed, albeit there might be a waiver in cases of emergency and government use, so those national emergency sorts of situations. The scope and the duration has to be limited. The uses should be non-exclusive, non-assignable, and predominantly for the supply of the domestic market. And this is this ongoing concern that drugs will be manufactured and exported to other places, and that's really the parallel importing issue that they're trying to resolve here. And then there should be some kind of adequate compensation paid. How much, it's not entirely clear how that'll be worked out. But at the end of the day, if parties can't agree, then they'll go to a court. And the decisions need to be open to review. And so essentially at the end of the day, what we rely on is the court system to determine what is a fair price. Built into that is then the politics of if you don't give a fair price, then drugs won't be made available in your particular jurisdiction, and the counter to that. If you're allowed to have a high price, you're going to attract more drugs, but less people are going to be able to afford them. Now, just to show you is that we do have the possibility of having Article 31 applied, and this is a French law. And what I wanted you to focus on is the words in italics. And really, the point what I just want to show you here is that here we have a developed country which has a law which can apply, which is consistent with TRIPS. And what that proves to you is that this is not impossible. This can be done, and it has been. We have the law applied, and this happens to be the French example of it. So essentially what it's saying is if in the event such medicines are being made available to the public in insufficient qualities or quality and abnormally high prices, then the minister responsible can grant a licence. So having expressed recognition here that access and affordability are criteria which allow you, and France is a developed country, it's one of the principal parties involved in TRIPS and enforcing TRIPS, especially in the TRIPS Council. It's saying itself that it can do this. So this is something possible. It is a solution. It is a possible solution, and this proves that even developed countries can do this. So that's really the point I want to make, is that you can do it. What I want to show you here is really the kinds of compulsory licenses that have been awarded around the world. This is a listing from 2001 to 2012. The main points I wanted you to see from this is that not many compulsory licenses have been granted, so very few countries are doing it. Most countries have only done one compulsory license, so the countries that are doing it are doing very few. Almost always it's the HIV/AIDS drugs, and that really probably accounts for the social groups who are pushing particular, I guess, arguments about access to these HIV/AIDS drugs. And I don't know what's going on in Egypt. It seems bizarre. It's just strange. So why do we have so few compulsory licenses? So I'm running out of time here, so I'll be fast. It's because of the delicate trade balances. I'd say that the biggest problem here is the United States Trade Representative. They have these 301 watch lists and their priority watch lists. And essentially what that allows them to do is that allows them to be aggressive towards countries that don't have sufficient, or who threaten compulsory licensing. And they've done this particularly successful in Thailand over decades now. Every time Thailand puts its head up and says, I'm going to have a compulsory license, they get whacked. The most exciting thing about here is the civil society rancor. I put that down, and you can see all the compulsory licenses. They've done a great job. Keep it up. Some people here today are going to talk about it. It's been incredibly effective. It's great to see that those civil society movements are working and having effect. It's really fantastic. We're also having some developments. The UNITAID medicines patent pool. We're also having some, which is increasing access to medicines. You've got the bilateral trade agreements. Matthew's talked about TPP. They're limiting access. And next, final thing I want to talk about is that these incredibly complex and unworkable schemes, and Australia is a classic example of this. And Australia's scheme does get held up as being a model of how you should apply it, but I just want to point out some of the problems. Essentially, we've got two schemes in Australia, one in the Patents Act. There are 3 criteria you need to this. You need to have tried without success in getting a license. You need to satisfy not satisfying the reasonable requirements of the public, and there seems to be no satisfactory reason for failing to work the invention. So 3 criteria. Then inside that there are incredibly complex words. They date back hundreds or tens of decades. We don't really know what they mean. It's a complex system. Then we have the Competition Consumer Act. Essentially, it's just a solution to anti-competitive practice. The major problems we have is the overly complex and uncertain terminology. So what do we mean by the reasonable requirements of the public? But over and above that, we also have a problem of court discretions. The court applies its discretion about what were the reasonable requirements to the public at the date of the hearing, not at the date of the application. So if you're a person who wants to get a compulsory license, you'll make your application. It can take a year, 8, 9 months, 6 months to a year to get your hearing started. And that's in that time the company can actually respond and start making things available to the public, not necessarily in a way that's going to benefit consumers, which means is that you're going to lose your application. Why would you do it? Why would you spend the money? And finally, just the conclusions. My main conclusion is we need compulsory licensing to be a credible threat. If compulsory licensing is a credible threat, then you actually do get an incentive to compulsory license by the patent holders, and you get the drugs out there. Thank you.